A 6-3 Supreme Court decision just blew up one of the oldest carry assumptions in America. And if you still believe the government can make you prove a special reason before you carry for self-defense, you may already be working off bad information. Quick question before we go any further. Are you subscribed yet? Because this is the kind of update that can change how you think about your rights, your permit, and your next trip across state lines. I break this stuff down in plain English without the legal fog, so you know what matters and what does not. If you care about staying legal and staying prepared, hit subscribe right now. Seriously. The worst time to learn a gun law changed is after a stop, after an arrest, or after you said the wrong thing to the wrong person. Here's what just happened, and why people are still getting it wrong. The case was New York State Rifle and Pistol Association versus Bruen. Before that ruling, New York used a rule called proper cause. That sounds harmless, but here is what it meant in real life. If you wanted an unrestricted carry license, the state could tell you normal self-defense is not enough. You need to show a special need. In other words, you had to prove you faced some danger beyond what regular people face. Think about that for a second. The average law-abiding person could say, I want to protect myself, and the state could answer, that is not special enough. That was the old assumption. Not just in New York, but in the minds of a lot of people across the country. Many believed carrying in public was more like a privilege the government could hand out to the chosen few. But the Supreme Court said no. In a 6-3 decision, the court said, the Second Amendment protects the right of ordinary law-abiding citizens to carry a handgun in public for self-defense. Not just inside the home, outside too. That is the part that changed the whole conversation overnight. Now, let me break down why that matters. First, the court did not say only famous people get the right. It did not say only people with stalkers get the right. It did not say only business owners carrying cash get the right. The court rejected the idea that you must prove some extra special danger before you can exercise the right. Second, the court did something else that shocked a lot of lawyers. It rejected the balancing test many lower courts had been using. Before Bruen, courts often asked if a gun law seemed reasonable based on modern public safety arguments. After Bruen, the court said the test starts with the text of the Second Amendment and the nation's history of gun regulation. That is a major shift. Third, this decision changed the pressure on states. If a state had a system where officials could say yes to one person and no to another based on vague judgment, that system suddenly looked much weaker. That is why people said old carry assumptions got shattered overnight. Because they did. But here's the crazy part. A lot of viewers heard about Bruen and jumped to the wrong conclusion. They thought, great, permits are dead, sensitive places are dead, I can carry anywhere now. No, that is not what the court said. And if you believe that, you could walk yourself straight into a criminal charge. The court was clear that many shall-issue permit systems can still exist. That means states can still require objective things like fingerprints, background checks, training, and paperwork, as long as officials are not making you prove some rare, special reason to carry. That is the key difference. Objective rules are one thing. Open-ended personal judgment is another. Here's a simple way to think about it. Old may-issue style rules often sounded like this. Convince us you deserve the right. Shall-issue rules sound more like this. Meet the listed requirements, and we issue the permit. That difference is everything. If this is helping you make sense of the noise, imagine what you'll get from my next breakdown on the exact words that can protect you during a traffic stop when an officer asks about a gun. Subscribe now so you do not miss that one, because that video could save you from making a very expensive mistake. Now this is where it gets interesting, because Bruen gave gun owners a major win, but it did not erase every carry law in America. And this is the part nobody talks about enough. The same opinion that expanded public carry rights also reminded everyone that some places can still be off limits. The court pointed to examples like schools, government buildings, legislative assemblies, polling places, and courthouses as sensitive places. In plain English, that means the government still has room to ban guns in certain locations. So if somebody online told you, Bruen means I can carry everywhere now, that person is gambling with your freedom, not theirs. Imagine this. You get your permit. You watch one loud video online. The guy says, you're good anywhere the Constitution goes. So you carry into a courthouse parking area, a school event, or building with rules you never checked. Then you find out the hard way that Bruen did not wipe out sensitive place restrictions. That is how people get burned. Not because they are evil, not because they are reckless, because they heard one dramatic sentence and never stayed for the details. Here's what most people get wrong. They confuse a constitutional right with zero rules. Those are not the same thing. Free speech is protected, but you still cannot threaten people. The right to travel exists, but you still need a valid license to drive in many situations. Same idea here. Bruen strengthened the right to public carry. It did not create a free-for-all. And wait, there is something even more important. Bruen did not create national carry reciprocity. Let me say that again, because this mistake is everywhere. The ruling did not mean your permit works in every state. It did not mean permitless carry in your home state automatically protects you while traveling. State lines still matter. Local rules still matter. Magazine rules may matter. Duty to inform rules may matter. Vehicle storage rules may matter. Here's a hypothetical example to explain this. Let's say you live in a state with permitless carry. You drive into another state for work. You assume, the Supreme Court said I have a right, so I'm covered. But the state you entered may still require a recognized permit, may ban carry in more places, or may have rules on how the firearm must be stored in the car. If you did not check before crossing that line, your confidence can turn into a charge fast. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Let me give you another real-world angle. Some people think Bruen only helped concealed carry. Not exactly. The bigger point was public carry for self-defense, but states still have room to regulate how that works, especially if they can point to historical examples or objective licensing rules. So when somebody says, the court made every carry restriction unconstitutional, that is just false. And here is the part that shocked me. After Bruen, some lower courts struggled with how far the history test should go. Some acted like the government needed to find an old law that matched a modern law almost word for word. Others used broader historical comparisons. That confusion mattered because it affected real cases, real people, and real charges. So if you are watching this and thinking, okay, what changed for me? Here is the honest answer. If you live in or travel through a state that used to demand a special need to carry, Bruen was huge. If you thought the government could deny ordinary people just because they were ordinary, that assumption is gone. But if you think the case gave you a magic shield against every gun law, that assumption needs to go too. Hey, real talk for a second. Most people watching legal videos never subscribe, and then they miss the follow-up that answers the question they actually needed. Don't be that person. Join the community of gun owners who want the facts before the rumor mill gets to them. Hit subscribe now and stay ahead of the next court move instead of hearing about it after the damage is done. Now let me explain why this story did not end with Bruen. Because if Bruen shattered old carry assumptions, the next big question was this. How far does that logic go? Could almost any gun restriction now be challenged? Could dangerous people still be disarmed? Could the government still act before violence happens? That is where another Supreme Court case enters the picture. United States versus Rahimi. And this is where a lot of people had to slow down and rethink the extreme takes. In that case, the court dealt with a federal law that bars gun possession by people subject to certain domestic violence restraining orders. The question was whether that kind of law could survive after Bruen. The court said yes. In plain English, the justices made clear that the right to keep and bear arms is not unlimited. They also said history does not require a perfect twin from the 1700s. The government does not have to find an old law with the exact same wording and exact same setup. It needs a relevantly similar historical tradition. That matters a lot. Why? Because after Bruen, some people acted like if there was no exact old-time law matching a modern law, then the modern law had to fall. Rahimi pushed back on that. The court basically said, slow down. History matters, but you were looking for a workable analogy, not a photocopy from another century. Now, this does not erase Bruen, it explains it. Bruen still killed the special need carry rule. Rahimi did not revive that. What Rahimi did was remind everyone that courts are supposed to look for harmony between the Constitution and lawful regulation, not manufacture conflict, where history supports regulation. Let me break that down for you in a practical way. First thing, ordinary law-abiding adults cannot be told. You need an extraordinary reason to carry for self-defense. That old assumption took a direct hit. Second, states can still use objective permit systems. Third, some places can still be off limits. Fourth, people who pose certain proven dangers can still face disarmament. Under laws the court finds consistent with historical tradition. That is the real map right now. Here is a scenario you should think about. Imagine you are at a traffic stop and you have a lawfully owned handgun in the car. You know Bruen. You watched a clip online. You think, I know my rights. But do you know that states' duty to inform rule? Do you know whether your permit is recognized there? Do you know whether the glove box counts as concealed carry in that state? Do you know whether the place you're headed is a restricted location? Rights matter. Details matter too. Do not make this mistake. Do not use Supreme Court headlines as your entire legal plan. A headline may tell you the direction of the law. It does not tell you every step you need to take tomorrow morning. And there is one more thing most people never hear. Even when the Supreme Court gives a big ruling, states often respond with new laws, new permit rules, and new sensitive place definitions. Some of those laws get challenged. Some survive. Some get blocked for a while. Some come back in a different form. That means your safest move is not to memorize one case and think you are done. Your safest move is to keep checking the current rules where you live and where you travel. This information moves fast. Court rulings, state responses, and carry rules can shift before most people even hear about them. Subscribe right now so you catch the next update while it still helps you, not after you already crossed a line you didn't know was there. So here's the bottom line. The 6-3 Bruen decision shattered the old idea that you must prove some special reason before carrying a handgun in public for self-defense. That was the big change. But the ruling did not erase permits, did not erase sensitive place restrictions, and did not give you a pass to ignore state law. If you take one thing from this video, let it be this. Your rights are real, but so are the rules that shape how you use them. Stay informed, stay careful, and never let a viral headline become your legal strategy. If this breakdown helped you see the difference between hype and reality, subscribe and stick with me for the next one. I want to help you protect your freedom without stepping into trouble you could have avoided. And one last simple reminder. This video is for education only. Laws change, facts matter, and for your exact situation, you should talk to a qualified attorney in your state.